Good evening, everyone. I first want to thank you all for braving the storm and coming out to join us for this Outlaws event this evening tonight. The Outlaws organization is a student organization comprised of LGBT and allied students here at the Quinney College of Law. So this evening's event relates to the recent decisions of many states to strike down bans on same-sex marriage. This has led some religious groups to fear that their religious freedoms are under attack. So while the Supreme Court currently prepares to hear the same-sex marriage cases, the country is seemingly at odds on finding a balance that satisfies the relevant groups' identities, practices, and beliefs. We are extremely honored and privileged to have both Professor Frederick Geddix and Professor Clifford Roski here with us tonight, who are both experts in these fields, and they're going to discuss the relevant and critical issues that affect our law and society today. Professor Frederick Geddix is visiting us today from BYU, where he teaches courses on the 14th Amendment, jurisprudence, structures of the Constitution, and freedom of religion. Professor Geddix is widely published on law and religion, and his current research is focused on legal issues and problems posed by federal and state religious accommodation statutes after the U.S. Supreme Court's decision in Burwell v. Hobby Lobby. And Professor Roski teaches courses here at the Quinney College of Law in constitutional law, criminal law, and gender and sexuality in the law. Professor Roski is on the board of directors of Equality Utah. He is widely published in areas relating to LGBT rights and has provided legal commentary on issues related to sexuality, gender, and same-sex marriage to numerous press outlets. With no further ado, Outlaws are pleased to provide a dialogue between two nationally recognized experts within the fields of civil rights and religious liberties. Thank you.
Do you want to start or? No. Okay. I'm very pleased to be here. I appreciate the invitation from Outlaws and that introduction by Kendra. We talked earlier about maybe we should have a whiteboard. And I know I'm not in Utah County anymore because the only markers available were red and black. Cliff and I are each going to talk for about 10 minutes. This is a horribly complicated area. And so we thought that I would give 147 years of constitutional history in 10 minutes. And then Cliff would integrate that with maybe 50 years of anti-discrimination history that fits into the constitutional history. So these are the touchstones up on the board, and we'll see how fast we can get through these. We do want to get to the question and answer session. We both think that that's actually more interesting than the things we'll have to say, but at least what we'll have to say will set the table for that, and I think help generate a really engaging discussion. So the civil rights cases, these are actually cases decided in the 1880s. Actually, maybe the first one was 1879. It's a little-known fact, and I mean little-known in the United States, that the Constitution does not apply to private action in most cases. There are a few provisions that do. I mean, the 13th Amendment outlaws slavery, and it outlaws private slaves and not just government slaves. And the government can regulate commerce by private people and not just commerce by the government. But in most cases, the Bill of Rights, for example, only binds the government. Individuals are not bound by the Bill of Rights. They're not bound by the Free Exercise Clause. They're not bound by the Equal Protection Clause of the 14th Amendment. How, may you ask, do we have the Civil Rights Act of 1964, which prohibits discrimination? How can that prohibit private discrimination if the 14th Amendment doesn't apply to private individual action? It was passed under the Commerce Clause because of these civil rights cases, which interpreted the state action requirement very narrowly of the 14th Amendment. So one of the things everybody needs to keep in mind to orient yourself in these decisions is that is that the Constitution, at least the relevant parts of the Constitution in this area, only apply to the government, only bind the government. Equality norms of the 14th Amendment do not constrain individuals. So now we can fast forward. We did pretty good with that. We can fast forward to Sherbert versus Verner. This is a case in 1963. Adele Sherbert was a factory worker in South Carolina and a Seventh-day Adventist. And for quite a while, they'd been able to accommodate her religious preference of not working on Saturday. But eventually, the factory reached the point where they couldn't, and she refused to work on Saturday, refused to show up for her shifts, and so they fired her. And she applied for unemployment benefits, and she was denied unemployment benefits because she had not made herself available for work. You know, if you've ever been unemployed and had to collect unemployment benefits, you know, you have to prove to the unemployment agency that you're willing to work. And they did not believe that her religious belief of not working on the traditional Sabbath, Friday evening to Saturday evening, was a legitimate reason for not working. And so her case went to the Supreme Court, and she won. The Supreme Court held that government had to show a compelling interest before it could infringe upon religious rights. And the extremely modest, infinitesimal increase in unemployment insurance premiums that would result from giving unemployment insurance benefits to people who were terminated for refusing to work on their Sabbath simply wasn't a compelling reason for denying Mrs. Sherbert unemployment benefits. The Supreme Court has decided 4 more cases along the lines of Sherbert v. Verner. But this is the one that created what we would call a presumptive right to a religious exemption from a burdensome law. Now notice what's going on here. It was the government that had burdened Mrs. Sherbert's religion. It had refused to give her an entitlement, something that she was entitled to under the law because of her religion. So she wasn't suing her employer and asking for her job back or trying to get damages or anything like that. This goes along with the civil rights cases. This was a holding that the government had to show a really important interest, a really important goal that it was trying to reach by burdening religion before it would be permitted to do so. That was the law from 1963 until 1990. In 1990, the Supreme Court reshuffled the religious liberty deck, the free exercise clause deck, in a case called Employment Division versus Smith. Smith involved 2 Native American drug counselors who used peyote as part of their religious rituals. It's actually not quite as strange as it sounds. The research shows that the peyote rituals actually were very effective in helping many Native Americans cope with the alienation and distance they feel from Anglo society. But there was something, I guess, a little incongruous about 2 drug counselors using a prohibited drug, and so they were terminated from their jobs and applied for unemployment benefits and expected to receive them in the same way that Mrs. Sherbert had received her unemployment benefits. And the Supreme Court said, well, we've changed our minds. They didn't quite change their minds. They tried to show how the holding in Smith was actually consistent with the holding in Sherbert, but really they changed the law. And the new regime of religious liberty provided that the free exercise clause does not entitle you to an exemption or an excuse for disobeying the law, or does not entitle you to an accommodation from a law that burdens your religious belief, as long as it's a religiously neutral, generally applicable law. So obviously, if the government targets religion that's prohibited by the Free Exercise Clause. But if it's a law that applies to most everybody, and it's not framed in religious terms, then religious folks don't get an exemption. They have to obey the law like everyone else. This created really a firestorm of criticism of the Supreme Court in the aftermath of Smith in 1990. And so we saw planets line up in a way that they have never lined up before or since, and that is you found really hardline conservatives and really left liberals both angry about this decision. And that kind of coalition is unstoppable. We don't see it very often, but we saw it in 1993 with the passage of RFRA, the Religious Freedom Restoration Act. And it was passed unanimously in the Senate, and I think with, or maybe it was 97-3 in the Senate.
97-3.
Yeah. And unanimously in the House. Anyways, overwhelming majorities. When's the last time anything passed our Senate? 97-3. And RFRA, as its name implies, purported to restore the old regime of religious liberty under Sherbert, requiring the government to show that it had a compelling governmental interest and that there was no less restrictive way of protecting that interest except to burden religious liberty. In 1995, the Supreme Court reviewed some challenges to RFRA, and it held that RFRA only applies to federal government action. That the federal government, Congress had the power to regulate the federal government, but not the power to regulate the states under the 14th Amendment. And so RFRA was kind of cut in half. In fact, more than in half. About 3/4 of RFRA was lopped off because most religious liberty cases involve state action and not federal action. So then, the leaders of the original coalition that had passed the Religious Freedom Restoration Act said, well, we'll just get all our friends together and reassemble this coalition and pass a new law relying on a different provision of the Constitution, the Commerce Clause, that allows us to regulate the states and regulate private action. A few things had happened in the interim, however. Between 1993 and 1995, a few cases, notably one in California, was out of Alaska, I guess, in the Ninth Circuit. The Swan case had raised the specter of using the Religious Freedom Restoration Act as a defense to private discrimination that would otherwise have been prohibited by the Fair Housing Act or Title VII of the Civil Rights Act or any number of state anti-discrimination statutes. And of course, this is not something that the far left or the far right or even the center left or the center right could agree on. The left, the ACLU, other activists against discrimination on the basis of race or gender or same-sex orientation weren't willing to sign on to a law that would permit religious individuals to claim that they could be exempt from anti-discrimination laws. And so the Religious Liberty Protection Act, RLPA, never passed. What did pass was this sort of strange, a strange combination of left-wing and right-wing interests called the Liberty and Institutionalized the Religious Land Use and Institutionalized Persons Act. So this was something, a typical, I think, legislative compromise. The liberals get together with the conservatives and say, what can we do about this? And the liberals say, well, we really care about prisoners who are having their religious freedom violated in prison, and the right says, well, we don't really care much about prisoners, but we do care about churches that can't seem to get zoning approvals to remodel or do whatever. And so they said, hey, well, we'll do those two things. We'll do institutionalized persons, incarcerated persons, and we'll do land use. So we have the our LUPA, as it is called. So this sets the stage for Hobby Lobby. I don't think I need, well, I won't recite all the facts of Hobby Lobby. I think I've gone over my 10 minutes. So notice everything that's gone before that goes into Hobby Lobby and how it seems different. Hobby Lobby doesn't want to provide certain forms of emergency contraception, and this is not just the morning after pill or the week after pill, but also IUDs, which are among the most cost-effective forms of contraception, and they're quite expensive for anyone. I think no matter what you're making, $500 to $1,000 is not pocket change, and of course, if you're a working class person, as most of Hobby Lobby's employees are, $500 to $1,000 out of pocket is serious money. So they didn't want to supply those, and they claimed that the contraception mandate burdened their religious practice. Hobby Lobby is a corporation. We won't even go there, how a corporation can exercise religion. But what was new about Hobby Lobby was it was one of the first times that a commercial entity, a commercial business, doesn't matter whether there was a corporation or a partnership, had claimed the protection of RFRA, a religious liberty statute, and claimed the power to exercise religion in the commercial realm. The other thing that happened in Hobby Lobby, or an additional thing that happened, is RFRA provides, of course, the contraception mandate is a federal regulation, so RFRA applies to it. It was part of the 1/4 of RFRA that was not lopped off by the Bernie case. RFRA provides that only substantial burdens are protected. The government only has to show a compelling interest in the least restrictive manner if it is a substantial burden on religion. Who gets to decide? It gets to decide if a burden on religion is substantial. Well, Hobby Lobby held that the government can't decide that the religious practitioner decides it. So if the claimant, the person who claims that his or her religion is burdened, really all you have to do is claim that it's burdened. The only thing the government can do in response is say, you're lying. You don't really believe this. You're doing it for other reasons. And you can imagine that even the most aggressive government lawyer really doesn't want to start off a case by claiming that the sympathetic religious practitioner is lying. And so it essentially cedes the entire ground on substantial burden to the religious practitioner. I think that's probably enough to hand the baton to Cliff.
That's great. It's incredible to have someone with Fred's expertise to be able to sum up that. It's just one of the frustrating things about this is that it is about as hot as a topic gets and about as complicated as a topic could get. And that just creates a lot of confusion. And I think if you now think back to the governor of Indiana, he signed a state RFRA. So after Bernie, where the Supreme Court said RFRA applies to the federal government but not to any of the states, states started passing their own versions of RFRAs, mini RFRAs. And Indiana just passed one, and someone said, well, you just signed a law that legalizes discrimination against LGBT people. And I think his first response was, what are you talking about? I signed a law called the Religious Freedom Restoration Act. It didn't say anything about LGBT people or discrimination in it. And then they said, well, that's what it does, doesn't it? And he said, I don't know, and I don't really want to answer that question. And it didn't go very well, Journalists have a way of getting an answer to a question. So I was tempted, as Fred was talking, to start putting up dates, because I'm going to tell you another story that begins actually with the civil rights cases. It's much faster. I'll probably be done in less than 5 minutes. So what was the Civil Rights Act of 1874? Is that what that was?
Well, the civil rights cases were in 1879.
But they struck down a Civil Rights Act, right? The first federal anti-discrimination law was passed in the wake of the Civil War. I'm forgetting the year.
1866.
66. Okay, so this was the Civil Rights Act of 1866. You don't hear much about it because it didn't last very long. It was struck down in the civil rights cases of 1879 or 83 or whatever. And the reason it was struck down is it said no one can discriminate. Right? So no business can discriminate against anyone. And the Supreme Court said, well, you can't do that. That the Constitution bans the government from discriminating, and Congress can't go so far in banning discrimination that it binds private actors, right? So there was a problem there. It's actually parallels Bernie. And so for a very long time, there were no federal civil rights laws, no federal anti-discrimination laws until 1964. So I never noticed the coincidence right after Sherbert. The Civil Rights Act of 1964, a historic piece of legislation. Well, how did they do it? How did Congress ban employers and landlords and private businesses from discriminating? If the Supreme Court said they didn't in the late 1800s, they used, instead of the Equal Protection Clause, effectively, they used the Commerce Clause. They said any business that operates in interstate commerce, which at the time was, and still basically is, defined as almost any business, because they're in interstate commerce or affecting interstate commerce, we're going to regulate them as interstate commerce actors. We're going to use, Congress has the power to regulate interstate commerce, and we're going to say, it's as a matter of commerce, you can't discriminate in employment, in housing, in what's known as public accommodations, that is what kind of customers you serve. And the real impetus for the Civil Rights Act was to ban discrimination based on race. That was clearly what the conversation was principally about. And there's a story about this. Feminists had clearly asked for to include the word sex in there too. It probably wasn't going to get very far, it looked like. And then someone who opposed the Civil Rights Act, didn't want to ban discrimination at all, said, I know how to kill this bill, let's throw sex in there. And it didn't work. It passed anyway. And so the law bans discrimination based on race, sex, religion, and then color and national origin are very similar to race. So race, sex, and religion is a pretty good summary. It applies to employment, housing, public accommodations, and many other things eventually. And in fact, the housing came in '68. So in the '60s, we get these federal anti-discrimination laws. They do, the employment and housing parts, note a couple things. They certainly did not ban discrimination against gay or lesbian, gay, bisexual, or transgender people. Indeed, they didn't even ban discrimination based on disability, or many other characteristics that are now protected. In the 1970s, the year I was born, 1974, the very new LGBT movement. So the Stonewall riots are generally regarded as the birth of the LGBT movement in 1969. 5 years later, I think in 1972, a city, East Lansing, Michigan, passed the first anti-discrimination law, but it was a city ordinance in East Lansing to protect gay people. And a surprising number of cities started passing these laws in the early 70s, really rapid gains. And then in '74, it went to Congress and said, let's put what they then called sexual or affectational preference in the Civil Rights Act. Everywhere that race appears, everywhere that sex appears, let's put it in everywhere. That didn't get very far. That bill was introduced every year and died in committee pretty much every year. And then, so let's see. I want to hit pause in that story. There are still no federal laws banning discrimination against LGBT people. So The story doesn't change a whole lot. But something else happened that Fred mentioned briefly. In 1989, Wisconsin passed a law banning discrimination based on sexual orientation in employment only. It's the first state law of its kind. And then in the next 3 or 4 years, you got about a half dozen states doing similar things. These laws only protected lesbian, gay, and bisexual people. Transgender people really weren't even on the map at that point. And so you get state LGBT civil rights laws in the early 90s. So that's between Smith and RFRA. And Fred mentioned this briefly. Also during that little period, 1990 to 1993, there was a case in Alaska and Minnesota, I think in one other state, I'm blanking on, it might have been Massachusetts, it was Massachusetts, began to litigate. Landlords were saying, we don't want to rent. Some of the states in their housing laws said you can't discriminate based on marital status. So when you rent your apartment, you have to be willing to rent to unmarried couples. And religiously conservative landlords said, we don't want to do that. And so first they invoked Sherbert for protection, the free exercise clause. And they said, this violates our free exercise rights. And it wasn't clear whether they were going to win. The country's interest in banning race discrimination, everyone recognizes. The country's interest in banning discrimination based on marital status, much less clear. When you marry, you get about 1,500 legal benefits that unmarried people don't. You could call all of them discrimination based on marital status. So the idea that landlords and their religious freedom could be trumped by an unmarried couple, this was not an obvious outcome at the time. And then under Sherbert, they had a chance. Under Smith, these landlords didn't have much of a chance. Anti-discrimination laws, like unemployment benefits laws, or drug laws in Smith, they're neutral laws. They apply to everyone the same, every landlord, and so if they can't get any special exemptions under Sherbert, they lose. So they looked like they were out of luck, and then RFRA passes. And all of a sudden, the landlords are excited, and then maybe they can cite RFRA. And so you get these cases percolating in the early 90s about landlords discriminating against unmarried couples in the name of religion and religious freedom. And actually, I think it was 94, that one case was appealed to the Supreme Court, and Justice Thomas, the court denied cert, declined to hear the appeal, but Justice Thomas wrote a dissent saying, this is a live one. We decided Smith, Congress overruled us, and we've got this issue, and we need to hear this case. Didn't hear the case, and then in Bernie, it kind of got put aside because now RFRA didn't apply, as Fred said, 3/4 of it doesn't apply. It doesn't apply to the states. And so that was the beginning of this claim that religious freedom, as far as I know, I haven't looked into it deeper than that, could be used as a basis for discrimination. There were claims during the civil rights era. There was a segregationist restaurant owner who said that his religion required him to serve only white people, not black people, and he lost. That claim was rejected by the courts. Title VII and the federal anti-discrimination laws say that religious organizations can discriminate based on religion, but not on sex or race or national origin, but only on religion. It makes a certain amount of sense. How can a religion not discriminate based on religion? It's not going to be much of a religion if it can't discriminate based on religion. And so the question of whether either the Free Exercise Clause or now RFRA is a defense to discrimination claims kind of disappeared for a while, or percolated in the courts below the radar. And now it's more squarely posed because more and more states are banning discrimination based on sexual orientation and gender identity, and more people are saying, well, that violates my religious freedom. That in particular, you hear about the wedding photographer cases and the cake bakers and the florists. People saying, I know that the state has a public accommodations law. I know that in general, like a hotel and a restaurant can't turn away a gay customer because they're gay. By the way, that's only true in now 22 states, and I think 18 states protect gay and transgender people, 22 states protect gay people from discrimination in employment, housing, and public accommodations. And the question of, most of those states don't have RFRAs. A couple, there's overlap. But when you have a state that has a RFRA and an anti-discrimination law that protects LGBT people, that's where you get, like New Mexico is the photographer case. And so that was a case in which a lesbian couple sends an email to an organization, Elaine Photography, and she says, well, I don't want to do, it wasn't a wedding because weddings weren't legal in New Mexico, it was a ceremony. And Elaine Photography said, we don't do same-sex ceremonies. And they then actually, it was a tricky litigation move, they then sent another email pretending to be heterosexual, and they said, sure, I'll do your wedding. And they were like, okay, now we got them. And so they went to the Human Rights Commission in New Mexico and said they're discriminating based on sexual orientation against customers, they're not allowed to do that. They go to court, and Elaine Photography invokes a RFRA defense, among other defenses. Violates my free speech rights, my free exercise rights, and New Mexico has a RFRA. And in that case, the court said, our RFRA only applies when the government is burdening your religion, not a private person like this couple. And so it doesn't go that far. She also, I think, then avoided the question of whether corporations were persons. They said, I think, yeah, right, there was a sole proprietorship. And so then you have states like Indiana and Arkansas, where you have a Republican conservative majority who's frustrated that they're losing the same-sex marriage litigation in the courts and want to make a statement. They make the statement of, let's pass one of these RFRAs. Everybody's in favor of religious freedom. We can do this. But now people are starting to see the risk of, well, what does this mean, religious freedom? Why are you passing this law? And the funny thing, the way it's changed now is, in the discussion of why Indiana needed a religious freedom bill, people were saying, because if we don't, then people are going to be forced to bake cakes for same-sex couples. People are going to be forced to photograph same-sex weddings. So it's now like this. The two issues are more joined. And so the governor signs the bill, and then all of a sudden people are saying, well, that's the license to discriminate. And he said, no, it's a protection. It's not a discrimination. And there's a whole battle over it. And what happens in Indiana and Arkansas is a little bit different. They both passed RFRAs. Indiana added a clause that says this can't be used to deny service to anyone based on their race, sex, sexual orientation, gender identity, religion. The weird thing about that is Indiana doesn't have a law banning discrimination against LGBT people. So to say that the RFRA would have legalized that, it was already legal. And to then add to it, well, now that doesn't legalize that, it's very confusing. Like, when I can't legalize something that's already legal and you can't not legalize something, nobody really knows. It's a very strange situation where their RFRA apparently is not a defense to discrimination claims, but at least with respect to LGBT people, that's moot because you can just put a sign in the window, no gays allowed. That's legal there. And so that was a bit strange. Arkansas passed a law. A big question is, do these RFRAs apply to disputes between two private parties? The federal RFRA, it's not clear. Courts disagree. The new trend in places like Indiana and Arkansas is to write it and clarify that it does. That is, it's a defense you could raise in any proceeding about anything. The theory here is that the state actor is the court itself by hearing the dispute. And so Arkansas passed one of those, people freaked out, and they said, okay, let's put it back. We'll put it like the federal, we'll make it unclear. That was the end of Arkansas, right? So it's like, and so that's where we are. That was more than 5 minutes. It's very complicated. But we are very anxious to hear your questions, whatever they are. Please.
The court is the state actor. Was that ruled on? Is that something that's flown, or is that just an argument?
I think it's just an argument right now. I don't think it should be.
I was just going to say that would make almost
It's one important. I mean, maybe I actually don't know how important it is, but they don't mean that the court, in doing this, then is subject to the Constitution. They mean that, as a statutory matter, we pass this RFRA protection. Its source is the legislature, not the Constitution. Right? These are laws being passed by the legislature, and they say we're providing you a defense as a matter of Indiana law, and the legislature gets to decide when you use it. Right, so they could say you can use it whenever you want. So that's essentially in any judicial proceeding. So it's so funny. It's become about LGBT discrimination. It's not in any particular way about that. It could be used if you don't want to have your child immunized. You want to send your kid to public school, but you don't want to follow the immunization rule. Can you bring a religious liberty challenge to that? Yeah, and it's not even clear. In Utah, all discrimination cases are brought by the Utah Labor Commission initially. That's the government. So this issue of private party versus government is not actually, the big issue is religious freedom, discrimination. Which one will trump? And legislatures will decide that because they're passing both of the laws.
I do think, though, it's an important issue. I think there's a difference between a court being open to hear all lawsuits, and you're right, if that were state action, then everything would be state action. But these RFRAs specifically authorize the courts to grant relief. And so that kind of specific delegation of authority to the courts to give exemptions to religious people might be different than the normal operation of the courts. That would be the argument. Beyond, what Cliff has said, which is creating the defense in the first place is a legislative act, not a judicial act. We're pretty far out in the weeds right now.
Sorry. I'm sorry. Go ahead.
I appreciate the categorization that you've gone through, and I'm really curious what makes the Utah law, Senate Bill 296, groundbreaking compared with anything else that other states have done?
First, I would not describe it as groundbreaking legally. Yeah, I know.
Yeah.
Culturally, it's groundbreaking for all the reasons that we can imagine. RFRAs are open-ended. That is, they apply to everything. All government action has to comply with this compelling interest test. That's what Indiana did, that's what Arkansas did, that's what the federal statute does. If you can imagine government action that burdens religion, and there's a RFRA in the neighborhood, then that RFRA will apply to it. That's not what Utah did. Utah took two discrete areas, employment and housing. I guess we could throw in 297. So
well, let's
it took several discrete areas and said discrimination is banned in these areas, or accommodations are permitted in these areas, and then it specified the discrimination that's banned and the accommodations that are permitted. So there are still things to be worked out in the Utah statutes, but they're not open-ended. They can't be used as a license to discriminate beyond the licenses already granted in the law. And it's not even clear that that you can, I guess the 297, Cliff and I were talking about this before.
Normally, I don't think 297 is regarded as groundbreaking by anyone. I don't think there's ever been a headline. That 296 is the bill that people have described as groundbreaking, and it's sort of so. There was a RFRA introduced. Representative LeVar Christensen, introduced a RFRA. This was House Bill 322. This bill was an extraordinary bill. This would have been beyond the federal RFRA, beyond the Indiana RFRA. It would have been, if I may say, the worst RFRA that you could ever imagine. Because groundbreaking. It would have been historic. That is, it said it had very strong protections. It used words like never and perfect, which don't appear in laws very often, for the protections. It shall never be infringed, perfect protections, that kind of stuff, and for religious freedom. And then, just to clarify, it went and amended our anti-discrimination laws to specify that religious freedom was a valid defense to claims of discrimination. So
On
this-
any basis.
Right, like this
Race,
whole
gender.
debate, it was like religion wins, discrimination loses. Interesting question. What happens when it's discrimination based on religion? That's weird. Really, what that shows you is it's about employers winning and employees losing. It has nothing to do with religion at that point. It did that. It didn't add any protections for LGBT people or anyone else. It simply attacked and eroded the existing protections in our laws. That died about 3 hours before the legislative session ended. Passed the House. What was SB 296? SB 296, so we have 3 major anti-discrimination laws in Utah to speak of, an employment law, a housing law, and a public accommodations law. They largely track the federal laws in these areas. You can't discriminate based on race, sex, religion, and now things like pregnancy and disability. And it added sexual orientation and gender identity to the employment law and to the housing law. It did not touch the public accommodations law. Public accommodation laws regulate what customers you have to serve. So in general, you can employ or fire anyone you want, rent to anyone you want, not rent to them, serve any customer you want or not. No shoes, no shirt, no service. I don't like you. I don't serve people with blue eyes. Any of that's totally legal. But you can't say, I don't serve people of color, or I don't serve white people. You can't say, I don't serve men or women. I don't employ them, all those things. Don't serve Muslims, Jews, Mormons. And so all that's illegal. And it added, for employment and housing, LGBT people, basically. That is sexual orientation, gender identity. It didn't touch public accommodations, which means in Utah, as in the majority of states, you can still turn someone away as a customer because they're gay or because they're transgender. What did it do with religious liberty? It's very easy to know what it didn't do. It didn't allow religious individuals to raise any religious liberty defense. It didn't allow religious businesses owned by religious families or individuals like Hobby Lobby. There's no Hobby Lobby defense in there. What it did was clarify the existing exemptions for religious organizations. Utah, every state and the federal laws have exemptions in their discrimination laws for religious institutions. They vary from state to state. Mostly, churches and their schools and such can discriminate based on religion, and that's it. That's not true in California, and that's not true in Utah. We both of our states have very broad exemptions for religious organizations. Instead of being exempt from only the religious discrimination provisions, they're just exempt from the law itself. So here and in California, churches can discriminate based on race, sex, disability, religion, whatever. So can religious schools. So can, in fact, in Utah, wholly owned subsidiaries of churches. So if a church wanted to open a Taco Bell, they could say, we only hire white people. It's very strange. Those didn't change very much at all in SB 296. The word affiliates was added. It was already really in there pursuant to a case, but it's been specified. Then there's some really interesting, and this is what I think is truly historic, but frankly the media missed it. There are some special protections for your speech outside of work. If you want to donate to Prop 8 or donate against Prop 8, if you want to march in the Gay Pride Parade or march in the Days of 47 Parade or whatever other parade, you can't then, when you come back into work, get fired for that. So there's a new protection for employees for their speech outside of work that applies to people of faith and to LGBT people. So the big key here is it provided equal protections. It didn't add a whole bunch of exemptions. Indiana and Arkansas added big exemptions with no protections. We added protections for both sides. And that's the other sense in which it's historic is 21 states had anti-discrimination laws that protected LGBT people. Every single one of them were democratically controlled legislatures. No Republican-controlled legislature had ever passed an anti-discrimination law to protect LGBT people. you would expected the first one to be Ohio or something, not the second most Republican-controlled, legislature. So that's new. A red state passing one of these laws is quite new.
If it was up to either of you to decide on federal level protections for LGBT people, should it be done through an ENDA or should it be done through an amendment to the Civil Rights Act?
So this is, I hit pause in that story and never finished. Right, so where we left off was in the early 90s, states started passing these laws. We're now up to 22 states. What's happening on the federal level? For the first 20 years, it was the ambitious version, include gay people in all of the Civil Rights Act. And then in 1994, for reasons that are a little bit unclear, the movement scaled back and said, let's just focus on employment. We have a lot of support on employment. Let's just really push that. And they drafted this law called ENDA. There was a lot of anti-affirmative action sentiment at the time, and opponents of protections for gay people were saying, we don't want gay people to get affirmative action. There's enough affirmative action already. And there was this concern that if gay people worked their way into the Civil Rights Act, trade-offs would be required that would harm everyone else that was protected by the Civil Rights Act. And they said, well, all right, fine, we'll do a separate law. So ENDA didn't amend the Civil Rights Act. It was a separate freestanding law. What happens when you separate out an unpopular group? Concessions. All of a sudden, there are huge exemptions for religious organizations, broader than any other existing. There was stuff about dress codes, there's stuff about no affirmative action, no quotas, lots of different little exemptions. And even that couldn't get passed from 1994 for 20 years. And last year, I think largely in the wake of the same-sex marriage cases and the huge victories that we were seeing in federal courts, all the major LGBT organizations said, enough. We can't even get this law passed, and it stinks. So let's just pull support for it and move back to a comprehensive, the old thing. Let's change the Civil Rights Act and add sexual orientation, gender identity. Little known fact, women are not protected within the federal public accommodations law. Many of the people in the LGBT movement didn't realize this, and someone pointed out, you're asking for more protections than women have. And they did a very smart thing. They said, oh, let's add women. And part of this is informed by the marriage, the wins in marriage. There's another dynamic here that's a little confusing, but it has to be said. Particularly transgender people are starting to win claims under federal laws that when you fire someone because they're transgender, you've discriminated against them based on their sex. It's already illegal to discriminate based on sex. Once transgender people start winning those claims, having a separate special law with a bunch of exemptions doesn't look so hot anymore. Because if they can win them in employment, they can win them in housing and public accommodation. Well, that's complicated, but they can win them just about anywhere. So now it's like, well, and there's even an argument that when you fire someone because they're gay, it's because they're associating with someone of the same sex. You can't fire someone for dating a person of color, even if they're white. That's race discrimination. So why can you fire someone for associating with a person of the same sex? That's sex discrimination too. That argument's gaining legs a little bit more now with the EEOC. So they thought, if we can win this stuff in litigation, let's not trade it away at the legislature. So it's become pretty clear that too much would be given away, I think. And the big cutting edge issue will be if, for example, Georgetown could decide it only wants to hire Catholic janitors, they're legally allowed to do that because they're a religious school. What if they fire someone because they're gay and they say that's based on religion? So the person says, you fired me because it's my sexual orientation or my sex, and they say, no, it's because of your religion. You're violating the tenets of our faith. That's a total, no one knows. That's the big issue to be worked out at the federal level. No one knows how that's going to go.
So whether that's accomplished by legislation or litigation, what would be the effects on churches as far as marriage even, and membership and things like that?
You know, this is one of the giant red herrings in the whole debate. Some of you, if you were following the Prop 8, one of the advertising tropes that went out there was, Mormons would have to perform same-sex weddings in their temples. I can't think of anything more absurd from a constitutional standpoint than that. There is utterly no basis for that. No one's arguing that. So I think there are conflicts that need to be worked out, but they're not at the fundamental level that are usually portrayed in the rhetoric. So, assuming the Supreme Court recognizes either a constitutional right to same-sex marriage or what would amount to the same thing, a prohibition on discrimination in issuing marriage licenses on the basis of sexual orientation. I mean, that seems likely. It's not certain, but likely. No cleric of any church is ever going to have to perform a same-sex wedding if he or she doesn't want to. No cleric now, as we sit here today, has to perform any wedding that he or she doesn't want to perform that violates religion. I mean, that's just constitutional bedrock. If there is such a thing, that's it. No house of worship, no church, no temple, no synagogue has to be opened to the public to allow any sort of wedding. I mean, think about it. If I showed up at a synagogue and say, I want to be married in your synagogue, and they say, well, you're not Jewish, and I say, discrimination, I mean, it's just absurd. That doesn't happen now, so it's not going to happen then.
Well, yeah, but so Professor Roski is talking about new LGBT rights being gained under the Civil Rights Act, under the sex discrimination thing. Mm-hmm. So can churches discriminate based on sex right now?
Well,
no?
Of course they can. I mean, there is not, to my knowledge, a female Catholic priest.
Well, but wait, so that is, a church can discriminate in its selection of ministers, right?
Yeah.
And that's very broadly defined. The church gets to say who a minister is. And so a recent case, 2012 from the Supreme Court said, a church can discriminate based on even disability in selecting its ministers, but it can't discriminate, like when hiring the janitor, based on disability.
Well, actually,
right?
It can, and it's nonprofit activities. It can.
Oh, that's right.
The
Amos.
Amos
Yes,
case.
yes,
See,
yes,
it's complicated.
Yeah.
Yeah, a church.
But wait, no, based on religion, not based on other character. That is.
Well, that goes back to the issue.
Yeah.
That
So Title VII says that churches, if we're talking about ministers, churches can do whatever they want.
Yeah, but here's how it would work. I regret to say this happens at BYU more times than I would like to admit, and certainly than BYU admits. But someone wants to be dean of a college, and it's a woman. And there's a lot of angst in the LDS Church, as many of you know, about women in supervisory positions over men. Well, BYU is a nonprofit activity of the LDS Church. Actually, it's even better than that. It's an integrated auxiliary. It's just an arm of the church. And so it is true the church cannot discriminate on the basis of sex. BYU can't discriminate on the basis of sex, but it can discriminate on the basis of religion. And it can say, our religion prefers that men have supervisory positions rather than women. And so, in a sense, it is and it isn't discrimination on the basis of sex.
I'm not sure that that's ever been litigated. So the thing that I know is that you're talking about Amos, right?
Yes.
So Amos is this case. It's from here. Mr. Amos worked at something called the Deseret Gymnasium, which was an affiliate, a wholly owned subsidiary of the church, technically the corporation of the presiding bishop, and he lost the janitor. Of course, was LDS.
Well, he's a supervisory janitor.
Oh, sorry. And he lost his temple recommend, is that right?
Yes.
I don't know the case. And so he lost his temple recommend, he gets fired because he doesn't have a temple recommend anymore. And there is something strange about a church requiring that someone working at a gymnasium is, of a particular faith. And so But Title VII said if you're a religious organization, you can discriminate based on religion. You can prefer people of your own religion. And so the church litigated that all the way up to the Supreme Court and won a unanimous ruling in its favor that Deseret Gymnasium could discriminate based on religion. But at least the EEOC says, but you can't use that as a pretext to discriminate based on other things. And so that's where I think we get, I don't know where we...
I agree that it's uncertain, but it wouldn't be a pretext. If, you know, I mean, you could argue that it's not sincere, but assuming sincerity, and I have to say, a lot of people in organizations with hierarchical male leadership are quite sincere when they say,
Yeah, sure.
you know, our church needs to be run by men and not by women, or by straights and not by gays. And so, I mean, it is, this is something yet to be litigated.
Yeah, and I was at this event in Washington, D.C., and they tried to pull together these sort of big leaders of the LGBT movement and the religious right, and they had them at this dinner, like the HRC's legal director and someone who I won't name, who's of a very large religious organization, influential here. And so they tried to sort of put them together and talk through this. You know, it's like, well, do you need temple recommends on the farming company? Everybody there? And so there was this question of this ability of religious organizations to discriminate based on religion. How far does that go? That, I think, is it's a doozy.
Right now, all we know is that it goes as far as the nonprofit activities of a church or a religious organization. Many people think that that's as far as it should go. I think that's as far as it should go. I think for-profit activity has traditionally been thought to be in the public realm and should observe public values. But one of the things that Hobby Lobby did is sort of crossed that line. Hobby Lobby is the first reported case. I mean, Hobby Lobby could not cite a single reported case in its briefing in which a for-profit corporation, or indeed a for-profit business of any sort, had been granted a religious exemption. This was the first time it happened. And so in the wake of the Amos case, it seemed like for-profit, nonprofit was an easy place to draw the line. It would be easy for judges to administer, you know, what's your status? Are you a business corporation or are you a nonprofit corporation? But now it appears that there's at least the possibility that these claims might be extended further. Danny?
I thought you just said a very interesting thing. You said, because it seems at least that in the public sphere that the public value should be upheld, but isn't that the crux of the fight against religion and discrimination, is what is the public?
Well, I think that's exactly what's at stake. The line between what is public and what is private is always indeterminate and contested. And I do think that the line between for-profit and nonprofit, with nonprofit being private, I mean, the quintessential, well, think about your living room, right? You invite people over to dinner. You're not required to observe the Civil Rights Act of 1964 in your living room. It's your living room. It's private. The government is the quintessential public entity. So that's on the other extreme. The government has to observe everything, the Constitution, the Civil Rights Act, all of that. And then there are various gradations. And I think there's a strong case to be made that traditionally for-profit businesses, the idea was, look, when you're making money off of the public, you have to serve all of the public. Actually, that was fairly, well, there's a strong argument that that was what the common law reflected until after the Civil War. Before the Civil War, if you were in business on a for-profit basis serving the public, you had to serve all the public. I mean, some of this goes back to 500 years in England, where you're on the road at night and it's dangerous to be out in the 14th century in England. And so when you came to an inn, they had to serve you because not serving you might result in your murder or robbery. After the Civil War, then of course the slaves are freed. African Americans have at least formally the same rights as whites under the common law, and the courts then started cutting back on public accommodation laws in the common laws. There's actually this sort of racist flavor to the refusal to allow or to require people to serve everyone. So I think I'm right, but that really is what is at stake. You often hear religious conservatives in particular saying, I have a right to practice my religion in public. And that means that I don't have to observe public values. I can be in public life and I can be religious. And that's a different kind of claim than we saw 30 or 40 years ago, when people just wanted to sort of be left alone in a kind of libertarian way.
I'm looking to kind of trying to process all this, and
That's copyrighted. No screenshots.
and in looking at the recent amicus brief that several major church organizations filed, I'm kind of trying to put together the same line of reasoning that they were maybe arguing like a religious liberty defense. Would that be something along like a RAFRA defense, and it would be a federal RAFRA or a state RAFRA, or what was kind of their? Because to me, it didn't really make much sense, the claim that they were making in that.
Well, I read that brief this morning, and I won't say that I threw it against the wall 4 or 5 times, because that might be dangerous to say that. But I found that brief very disappointing in many respects. Parts of it I thought were powerful and right. I think it was at least a tactical error, is at least a tactical error for LGBT folks to turn every act of discrimination into animus or hatred. It's not conducive to dialogue and compromise and engagement to say, you're acting out of hatred. I don't even need to talk to, haters gonna hate. And so that part of the brief I thought was useful, and actually a number of people have been saying this. Similar amicus briefs have been filed in the lower courts on this. I think that is helpful. But the idea that LGBT folks should be denied their equal protection rights so that religious individuals can exercise their own conception of religious freedom that is not even protected by the Constitution. It's hard for me to wrap my mind around that claim. The Constitution doesn't guarantee that you not be criticized for your religious beliefs. And so one of the arguments the briefs make is that, well, if same-sex marriage is recognized, then people who don't believe in same-sex marriage will be subject to criticism, and that will make it harder for us to live our religion, and therefore you shouldn't recognize same-sex marriage. I can hardly process that argument as a constitutional lawyer. I understand the position that the churches who filed that briefs feel that they're in. They feel embattled, and they feel that the space in which they can operate and be authentically themselves is shrinking. And that's a really disorienting feeling. All of us have been, I think, in those circumstances. You show up in a place and you realize that you're not going to fit in unless you do other things. So I understand the motivation, but the answer.
Can I say many people have made this observation, but this thing, don't put me in a closet.
Yeah, well,
right?
exactly.
I want to practice. I'm not just religious at church and at home.
Yeah.
I want to be religious in public. I want to be gay or LGBT in public. There's very similar, and the folks are meeting.
It really is deeply ironic to hear this kind of argument from this side of the aisle. But anyway, that's my reaction to the brief.
And I will say that the 10th Circuit was, the state of Utah presented this argument to the 10th Circuit. They didn't spend a lot of time on it. was not impressed with the argument. It doesn't really work as a argument in court. I think you can put it in an amicus brief, but it's just...
If you do have two constitutional rights, and that's not the case here, but if you did have two constitutional rights, then the job of the court is to figure out how to give the maximum amount of leeway to both rights. And it's complicated, it's difficult, but the answer is not, okay, we're just going to pretend this right doesn't exist. And that doesn't eliminate the conflict, it just submerges it.
I want to come back to one thing about Hobby Lobby that I found significant. One of the reasons that Hobby Lobby won and the government lost is the court said, well, you're telling us that you need to have Hobby Lobby pay for insurance. We'll then provide insurance to the employees to go to doctors, get their birth control, take the birth control they want. And you have already given an exemption to religious nonprofits from this requirement. So why don't you just give it to them too? And so it wasn't just that they were recognizing the free exercise rights or the RFRA rights of a for-profit corporation, but one of the reasons that they recognize that right is, well, if you give it to religious nonprofits, then you have to give it to religious for-profits. That you can't just you can't discriminate against for-profit companies. And that was, to me, an extraordinary step. The government did not need to exempt religious nonprofits from it. It chose to as a way of making more space in the public sphere for Georgetown University or not LDS Hospital, because it's actually not owned by the LDS Church, but religious hospitals, religious schools. They said, we're going to exempt you in the name of religious freedom. And the Supreme Court said, aha, if you exempt nonprofits, then you have to exempt for-profits under RFRA. That seems...
Yeah, and these are the conservatives. These are the ones who are always railing against judicial activism, and yet they paused about 5 seconds before rewriting a federal regulation, the consequences of which I am convinced they had no idea. It's easy. It was easy for the nonprofit accommodation to work, or at least its effect was limited, because nonprofit employment and employers, it constitutes less than 15% of employment, and religious nonprofit employment is just a fraction of that. So you're talking about not very many employers and employees when you provide an accommodation for nonprofit religious employers. When you expand that to all employers, well, that's a big number. And how many now will ask for exemptions? Well, if it had been Congress doing this, they could have held hearings and sort of put a number on that. Or if it had been an administrative agency, they could have held a notice and comment period and solicited comments and got a sense. But it's the Supreme Court. A bunch of 25-something law clerks, sorry to all of you who are, that's all it is 9 people and 36 law clerks said, hey, you can just do this. And it's the conservatives who did it. It drives me crazy. Can you tell?
Is it all that big of a stretch given, I was thinking less along religious lines than more about Chief Justice Roberts and Citizens United and his sort of feelings about business and corporations and kind of more freedom for corporations.
Absolutely. There's a really interesting aspect to this story about role reversals, the liberals and the conservatives. So when the Supreme Court first effectively recognized the free speech rights of corporations, it was in a case called Bellotti, one justice dissented, Rehnquist. He said, corporations are not people. They're artificial legal entities. We create them for certain purposes, and then we limit them for these purposes, and this is very strange. In Smith, when the Supreme Court reined back in religious freedom under the Free Exercise Clause, Justice Scalia wrote that decision. He said, if you allow every individual an exemption under the Free Exercise Clause, everyone is a law unto himself or herself. You can't do that. That's not law. That's chaos. Brennan and company dissented from that. So it's very strange. The ACLU must have been having a real party when RFRA was passed, right? And there's a lot of role reversals. Yeah. But it is true that Citizens United and related cases recognizing the First Amendment rights, the free speech rights, same amendment though, of corporations. And now, even though RFRA is not part of the First Amendment, it's certainly is attempting to piggyback on it. And so there's certainly, it seems like there's a lot of regret on different sides about the first time a claimant won under RFRA. The court said to Congress, effectively, we told you this was a crazy rule. It was a small sect that wanted to use a hallucinogenic tea, and they won. And the Supreme Court said, yeah, see, this is a little weird, isn't it? But Congress, you wrote it. Now there seems to be a different flavor coming out of Hobby Lobby, that at least some of the conservatives like it.
The Roberts Court, been about 15 religious liberty decisions that come out of the Roberts Court, either under the Constitution or under or LUPA or RFRA or various statutes. All but one of them vindicate the rights of group or corporate entities. Even the small, the Gonzalez case, the small hallucinogenic tea case, it's a case brought by an incorporated church. In fact, the first one to actually vindicate the rights of a person, an individual, was just last term in Holt versus Hobbs, and it was one of these our LUPA cases. It was a prisoner who wanted to grow a half-inch beard for his Muslim beliefs.
Please.
I'm trying to understand, assume a state has a RIPA that is essentially the same as the federal government, and they have an anti-discrimination statute. Who wins? Do you understand what
That's an excellent question.
So there's
Nobody knows.
Yeah, nobody knows. So there will be two questions. First of all, it will literally depend on whether the anti-discrimination laws are enforced by the government, like the state's EEOC office, or by the private party who gets fired. And you could go, that literally depends on the particular case.
Do you all understand what Cliff is talking about when he says that is, the government could enforce the law, or a private party could sue for damages under the law, and then the employer raises the RFRA as a defense. And it's that second step that is relatively new.
Yeah, and it's total, state by state and even case by case. The EEOC brings some claims, decides not to bring others, and gives you a right to sue. So the outcome might depend on something like that at the state level. So that's one piece. But then, go ahead.
Okay, let's assume that it's Utah and the Utah Anti-Discrimination Division brings the case.
So it's the government.
It's the government. So we don't have the private.
Of course, we don't have a referee either.
Right, but
let's
imagine,
assume, okay, a state. Let's assume it's a state that has both, and it's a state anti-discrimination division.
So then, so now it depends. So is it discrimination against a gay person, right?
Yes, and they're covered by
The state law. Yeah. So in order to satisfy a RFRA, you have to show a substantial burden. That seems very likely. There's going to be a question of, does the RFRA in the state track the federal on person is for-profit corporations, right? There's that issue. Is this a substantial burden? Probably is. And then, does the government have a compelling interest, first of all, in protecting gay people from discrimination? It's not real clear what the answer to.
That's really what my question was pointing out, because that is the anti-discrimination a compelling state interest, which is big enough to override?
There's two problems. Yeah.
Well, it's only clear that it is in case of race.
And sex.
No,
Well,
I would say it's not.
Okay, fair enough. Yeah,
And because of Hobby Lobby.
Yeah.
Your question was raised in Hobby Lobby as sort of one of these, little colloquies among the dissent and the majority. And the majority said, of course, all these horror stories about anti-discrimination are not true. Eradicating race discrimination is always a compelling governmental interest, but they didn't say anything about sex. They didn't say anything about sexual orientation. Didn't say anything about disability. So at least those 5 justices wanted to leave that open because it would have been really easy and more natural, I think, to say, all anti-discrimination statutes represent a compelling interest. So
yeah, it's very, and then this would have to be on a statewide. It gets very swirly at this point. The other thing is that the majority statement that eliminating race discrimination is obviously a compelling state interest is pretty incoherent, because they also said that when you're trying to satisfy RFRA, you can't have a generic, broad, compelling interest.
Right.
You have to justify the application of the statute to the person, the denial of this exemption. So why is stopping this person or these people from discriminating based on race a compelling state interest? You can stop most discrimination. Why isn't that compelling? And not these. So even that is not clear. But then is it the least restrictive means of stopping race discrimination in general to apply it to say how many people have religious objections to discriminate? So it gets essentially, to step back from this, RFRA demands a case-by-case inquiry. It demands a narrow inquiry. And so you might have to litigate this under employment, and then again under housing, and again under public accommodations. The rule might be different for wedding photographers and photographers who don't do weddings, and everyone else who has every other kind of business. So there's law. It's very hard to see. One of the distinctive things is by mandating case-by-case analysis, you can look forward to the next 30, 50 years of RFRA litigation. And this is just the question of discrimination. But then there's everything else that the government regulates, which is just everything else.
I guess at a fundamental level, I'm a little bit confused, because in these case-by-case bases, does the burden also then lie on the person who is doing the discriminating? Like, do they have to show where in their religion it says that I should or ought to deny service?
No, the test, and this is Hobby Lobby, the test was essentially, there were 2 factors. One is, do they have a sincere belief that these drugs, and it even extended apparently to whether the drugs prevented implantation as opposed to fertilization, because the science was debated on 2 of the 4 drugs, and the court just trusted Hobby Lobby on the science, which was extraordinary. Not the religion, right, but the science. But then the government didn't challenge whether they were sincere. There are a couple cases where sincerity gets contested. My understanding of those is, unless you're running a Ponzi scheme in the name of religion, you're sincere.
yeah, I mean, the sincerity cases tend to be things like, Church of the House of 3 tons of marijuana, that sort of thing. But if there is just the slightest colorable claim to religious belief, the courts don't want to go near it.
Because then you're not going to call your priest as an expert on your doctrine and decide, you're saying your doctrine means one thing, he's saying another thing. You get to decide what your religious doctrine is. There's a lot of, it doesn't have to be your church's doctrine, it can just be yours.
Yeah, you can be a really idiosyncratic Catholic. It doesn't matter if no Catholic believes like you, as long as you sincerely believe something as a Catholic, that's enough. So the only thing that can be interrogated is the person's subjective, whether they actually really subjectively believe something.
And then what would be the penalty for them following that belief? So
Yeah.
if Hobby Lobby had violated its belief, followed its belief and sort of violated the Affordable Care Act by not providing insurance, they would have been fined hundreds of millions of dollars. So that was the substantial burden. They had a sincere belief and a big fine if they followed it, and that was it. And there was the dissent said, what about the idea that you don't have to take these birth control measures yourself, these individuals, you don't have to give them to anyone, you don't even have to pay someone to give them to anyone, you have to pay someone to provide insurance so that someone else can give them to the people who asked them. And the dissent said, is that a substantial burden on this belief? Aren't we supposed to decide that? And
I mean, how is that any different from wages? Health insurance is earned as compensation. And, Hobby Lobby couldn't make the absurd claim that its employees were not permitted to use their after-tax wages to buy contraception that Hobby Lobby objected to. So why can they why can they dictate to their employees not to use their before-tax compensation in the form of health insurance? So all of that.
And basically what a RIFRA does is largely so if you have your sincere belief and you have the burden of the penalty, then the burden of proof goes to the government, and it's quite high. The government now has the burden of proving this exemption can't be allowed. So it's a tough thing to set.
Someone has a...
Well, I really want to preface this question because it's a legitimate interest to me, and I don't mean it facetiously. Forgive my ignorance if I come across that way.
It's impossible to be ignorant in this area. Nobody knows everything.
Well, and I don't even know if it fits the scope of this dialogue in particular, but if the Supreme Court, which is most likely, they recognize same-sex marriage on a national basis, what line is then drawn in terms of defining marriage? What is it that it is between man and a man, woman and woman, man and man? Where's the line then drawn in terms of that definition?
I think it's a very legitimate question. We're covering this in my sexuality class right now. That is every decision that a judge ever makes on any side has a slippery slope, and the big question is, depending on how a court were to strike down a law against same-sex marriage, different slippery slopes could emerge. So, for example, let's say it's not going to happen, but let's say the Supreme Court says, well, there's a history of oppression against gay people. Sexual orientation is a suspect classification. We're going to be very suspicious of any law that discriminates against gay people. Then the slippery slope really is effectively, first of all, any law that discriminates against gay people is going to go, but there's not that many left. And so that's not a big slippery slope. The other one would be, well, what's the next group, right, that's going to claim these special protections? What criteria did the court list that said that gay people qualified for the same kind of protections that other groups have under the Equal Protection Clause? Who else can qualify? Now, I have to say, the Supreme Court has not recognized a new suspect class since 1977. They've rejected many requests to do so. And in 85, they said, 85, they said quite candidly, we are not going to do this because we have no principled way to distinguish among groups. That's not good. They're out of that business. As a result, now they strike down laws in very narrow ways without telling you, frankly, very clearly why they're doing it, so that to sort of minimize the slippery slope problem for the foreseeable future. I think that's what's really going on behind the scenes. So, in 1996, they struck down a Colorado law that discriminated against gay people, and the way they explained it was very specific to the law they struck down. And then they did it again in 2003 with the Texas sodomy law, and then they did it again in 2013 with the federal DOMA. And so they always leave you guessing about what's coming next. They don't give you a clear signal because they're worried about the slippery slope. Similarly, I don't think they're going to find that same-sex couples have a fundamental right to marry and strict scrutiny applies, because then Big Love, the sister wives, they're literally litigating right now in the 10th Circuit, and they're going to claim the fundamental right to marry that every individual has and can't be burdened, and so blah, blah, blah. And frankly, a lot of people say, incest, completely different, but the major justification for incest laws is public health, and that's based on the idea that procreation leads to birth defects, but if you're a same-sex couple that's engaging in incest, you're not making a baby. So it gets complicated. Folks, it gets complicated. And so that's why I was a little surprised by the 10th Circuit held that same-sex couples had a fundamental right to marry because they're individuals, while they had a polygamy case pending on appeal to the 10th Circuit. That was extraordinary. They didn't have to do that, but they did, and so that'll be really interesting to watch. So a court has, in part, struck down Utah's polygamy ban as a violation of your fundamental liberty, and they're appealing to the 10th Circuit, who just decided that every individual has a fundamental right to marry.
Although it's only halfway, though, the polygamy case.
Yeah, it's only half of a ban, but when they win this one, then they'll come back for marriage licenses,
Probably,
perhaps.
yeah.
In terms of marriage benefits, then it's completely arbitrary, because now who isn't entitled to marriage benefits? If that argument.
So, I mean,
Right.
to say that there's a slippery slope doesn't mean to say that there's no principles. So there are some justifications. If you were to open up marriage to more than two people, the administrative complexities of that are pretty breathtaking, because you can't just say, well, then only 3 people, right? And so 25 people are the parents of 1 kid or the parents of 25 kids. I mean, so there may be reasons for limiting the number that don't apply to limiting the sex. There's some other ideas about polygamy, but.
I'd like your opinion on this hypothetical that is of local interest. It came to my mind after 296 passed. We know that down at BYU, there's either church-owned housing or affiliate-approved housing. At Snow College, the population of the students is more than 90% LDS. Would there be anything to preclude the Mormon Church from buying or building housing around that college, and then holding out discriminating rules?
So the answer to that is there never was anything that would have prevented that before 296, and there never is in 296 doesn't change in any. There was a lot of rewriting. This is part of the confusion. There's a lot of rearranging and editing that frankly, the Legislative Council does. It doesn't change the law, it just clarifies it. And so there was particularly a lot of rewriting in the housing code. Not a lot of it changed. So the short answer is it's always been the case that a religious nonprofit, if it owned dorms or housing in general, could discriminate under Utah law. Not necessarily under federal law, but
Is that true if the dorms are not affiliated with the university, if they're sort of freestanding?
oh, I thought she was asking about owned dorms.
So the church would own them, but it's at
Snow College.
It's
Yeah.
the same college.
But the church, any subsidiary, like Taco Bell, anything that a church owns in Utah is totally exempt from our employment laws. And I believe if they're renting out apartments from the housing laws, I think that's true too.
Even though the affiliation is kind of far removed from a religious use.
Ownership substitutes for affiliation under Utah law. That's a unique feature of our law. That's the one thing California doesn't have, that if you own it, you don't have to be affiliated. If you don't own it, then you can still be affiliated. Affiliation is essentially legal control. That's actually harder to establish. Buying something is a quick fix. Now, I can assure you that this is not going to happen, but it would be, it's permissible under pre-existing law, and that exemption for wholly owned subsidiaries. Our first anti-discrimination laws were passed in 1969, and they were in the original. They've never been changed.
So I think we'll make your question the last question, if that's okay.
I wanted to get back to the Hobby Lobby, and you just help me understand, how does the rights they were given as a corporation not impinge on the rights, the religious rights of their employees? I'm an employee of Hobby Lobby. I want something, but the owner of the company says, no, you have to abide by my religious priorities. How does, can a Hobby Lobby employee bring a case?
There's two answers to that. One is a really narrow technical one. And the technical answer is that at least the Obama administration has amended the regulations governing the contraception mandate to extend the nonprofit accommodation. See, under the nonprofit religious accommodation, all the employees still get the contraceptives. So if you work at Notre Dame, you don't get any contraceptives from Notre Dame, but the Notre Dame's plan administrator or their insurer provides the contraceptives. And the theory is, because it's a pretty good theory, it's backed up by some research, that it's a lot cheaper to provide contraceptives for free than it is to pay for prenatal care, childbirth, and complications. And so, once those regulations are put in place, you should get a notice as a Hobby Lobby employee saying, I don't know who Hobby Lobby's plant administrator is, but, Mutual of Omaha or somebody, will supply the 4 contraceptives that Hobby Lobby doesn't want to supply. So there's a modest burden. You'll have to fill out a form. You'll have to, get them directly from the insurer rather than through your health care plan, but you'll get the contraceptives. So that's the technical answer, is that once these regulations become final, you're not being deprived of anything. But the broader answer, your question is, I think, one of the most important ones at stake, that was at stake in Hobby Lobby and is at stake going forward. And that is, why should employees have to pay for the practice of their employer's religion? Why should they be denied generally available legal entitlements because their employer objects to them? And actually, it's even worse than that. That's bad enough. But employers, the standard of religious accommodation that's imposed on employers under Title VII, under the Civil Rights Act, is de minimis. Employers are not obligated to accommodate employee religion if the cost is more than trivial. And of course, employers can now apparently use RFRA to deny their employees benefits. And so employer religion is now much more strongly protected than employee religion. All of that is just, completely screwed up.
Yeah, and this is something I'm going to try to write about this summer, that no one, to my knowledge, has ever invoked the Free Exercise Clause or a RFRA to allow them to discriminate based on religion. Invoked it for race, invoked it for sex, sexual orientation, gender identity, but not religion. And that's peculiar to me. It strikes me as rendering the whole thing a little bit suspicious. Like, if you were going to discriminate in the name of your religious beliefs, the first way you would want to discriminate, the most strongest case, is based on religion. But no one claims that. And I think the reason is that it puts in stark relief what you said, and also Justice Ginsburg said in her dissent from Hobby Lobby, is this isn't really a protection for religious freedom. We have protections for religious freedom. You can't fire someone because of their religion, evict them, turn them away as a customer. This is taking religious freedom and giving it to the business owner at the expense of the worker, the renter, or the customer. And that comes in stark relief. For example, Chick-fil-A once had, obviously, Evangelical Christian Corporation. They do a lot of praying at work. They hired a Muslim employee. He didn't want to pray. They fired him. He brought a Title VII claim in. Of course, he won. Could they bring a RFRA defense to that? Seems like a pretty strong RFRA defense. He didn't want to pray with us. We want to pray. Right? If they're a for-profit corporation, never mind paying for health care. We're praying. Right? But that once you assert that claim, the whole thing doesn't look like religious freedom anymore. And so there's a real, in some sense, it's more about the rights of for-profit corporations as opposed to others, rather than what the really right is about, in my view. But that's a critique. That's a very ideological position I just took. So, it's not an objective view.
Well, I just want to thank you all again so very much for coming out tonight, and a very special thanks to Professor Oski and Professor Geddix for taking time out of their very, very busy schedules to start this dialogue with all of us.
It's our pleasure, and thank so many of you for turning out tonight, and to Outlaws for hosting this. Really, it's really been a pleasure. Thanks.
Thank you.
I just can't believe how many things are on that.